Can you talk about the current scenarios where blood is tested? What infractions, accidents, incidents can trigger the test?
Before a police officer can take you in for a blood draw, 3 conditions have to be met. The first is that there actually has to be probable cause to arrest you, so probable cause that you've actually committed a crime. The second is that you have to have exhibited objective signs of impairment that the officer can describe. Weaving, driving late at night, I guess, with your lights off, or the typical things that an officer looks at and decides to pull you over. And if you seem to be impaired, if they're looking at you and there's bloodshot eyes or slurred speech, same types of things that they look at for any kind of impairment. An officer is always looking for signs of impairment, irrespective of the substance, whether it's alcohol or marijuana or prescription drugs. Third, in order to actually take you in for a blood test, the officer has to have a reason to believe that what is causing your impairment is something other than alcohol. If you appear to be impaired by alcohol, the officer can smell alcohol in your breath. All that the officer can do is take you in for a breath test. They can't take you in for a blood draw.
Will the DUI blood test look for active THC or metabolized THC, and what is the difference?
It's in the text of the initiative itself. It's limited specifically to active THC, not to any of the inactive metabolites. So active THC is the psychoactive component of marijuana that actually causes the effects that cause impairment.
What are we going to do with 50,000 people who all of a sudden one day are no longer legally allowed to drive? As a home health case manager, I can tell you, if it is a chronically ill patient, not only are the costs medically, financially astronomical the minute a patient becomes homebound. You can look it up on Google. There are thousands of studies. Homebound patients that lose their license, that lose their privileges to drive, very often get much more chronically ill and cost even more money, and then they die. And what have you done, Allison, to take that into consideration and to help these people when you're going to incriminate them with I-502 when they're not impaired? They're being criminalized when they're innocent.
What I will say is that I've looked at the fact that there have been marijuana users in the state of Washington for a very, 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 very long time. There have been heavy marijuana users in the state of Washington for a very long time. There has been a medical marijuana law in this state since 1998. If you're concerned about whether or not you're going to be pulled over and convicted for DUI, that's already happening now. The law is that you can't be pulled over and charged with DUI unless there is exhibition of impairment. If you're not exhibiting impairment, that's not happening. If you believe that that in fact is happening or will happen when Initiative 502 passes, why? What is it that you think is going to change? A police officer can't look at you and see your medical status. A police officer can't look at you and see what your active THC concentration is. Nothing is going to change about how DUI laws are enforced. Police are still going to be looking for observations of impairment. They are still going to have probable cause to arrest you. They are still going to have reasonable suspicion that you're impaired. They're still going to have reasonable suspicion that that impairment is caused by something other than alcohol. And they're still going to have to make the decision to take themselves off the road and spend 4 or 5 hours with you going through the process of drawing your blood. The people who are getting charged with cannabis DUIs right now are getting charged with less than 5 nanograms. A gentleman was just convicted not too long ago for vehicular assault with 1.6 nanograms per milliliter of active THC. And he is in prison right now for that. Prosecutors don't care whether it's 5 nanograms. They'll charge you with carboxy THC, and you will get convicted because this is happening. The people that will be impacted by a 5 nanogram per milliliter standard that aren't already being impacted are those people who are pulled over, arrested, taken in, had their blood drawn, gotten charged with the DUI, had the test come back at or above 5 nanograms per milliliter of active THC, gone to trial, and convinced the jury to acquit them. That's the group of people that has anything to worry about, and that is not happening. And keep in mind that we have had zero tolerance THC laws in this country going back as far as 1983. If we really could expect reasonably a rash of all of a sudden police officers going out and rounding up lots of people and charging them with cannabis DUI, we should have seen that by now.
Why was it decided to not include a legal exclusion for patients so that they aren't held to the same per se DUID standards as recreational users, such as with Arizona and Rhode Island, who have exclusions for patients to their per se policy? And when you answer this, because this will go out to a general audience, and let's just assume a lot of people aren't that familiar with some of the language, so explain per se as well.
Sure. So per se standard means that if you are at a certain level of a particular metabolite or component in your breath or blood that is detected, that being at or above that level is in and of itself adequate evidence to find you guilty of DUI. So the way that this works with alcohol DUIs is that the prosecutor has a couple of different options. The prosecutor can either prove that you're impaired through the officer's observations, or prove that you were at .08 or higher, or both. And typically they'll introduce evidence of your impairment even if they do have the breath test. So that's how it per se works. But the point is that they need nothing more than the test result to determine that you're guilty of DUI. Or the jury can make the decision. With respect to, medical marijuana patients and DUI, the science doesn't support the distinction that's being proposed. Just as John said earlier, it doesn't matter if you're a patient or a heavy smoker, it applies to you the same way. The converse is true. Why would you make an exception that is just because you're a patient and not a patient? Why are some patients, not all patients use cannabis the same way, correct? Some people only need a little bit to make sure that they can eat a meal, or they need a little bit to go to sleep at night. Not every medical marijuana patient is a chronic pain patient that has to use marijuana day in and day out. And we also simply don't have the scientific studies to prove that even if you are a long-term heavy user, that you aren't impaired for purposes of driving when you're at 5 nanograms or higher. The science is what the science is. The science is, it's on the fact sheets, that when you get to 5 nanograms or higher, you're at an increased risk of crash. We don't have science that says otherwise, and I think that we will continue to see that be studied, and I think that if adjustments need to be made, that adjustments can be made. But the reality is that nobody wants impaired drivers on the road, whether it's marijuana, alcohol, prescription medications, sleep deprivation, or distraction by your cell phone. And if you want to ignore that fact, you can, but the voters of the state of Washington are not going to.